What is up, everybody? Welcome back to Truth and Transparency. It is Wednesday night. It's been Wednesday all day today, but this is Idaho4, the new docs. This is the state's reply to Hippler's batch number 2. The defense filed theirs under seal. The state, so I have the states. I'm going to rip the states out here. Got a busy night ahead of us. Got some bombs dropping in the Celebrate out of Delphi. So we're going to really talk about some shit. So join me all throughout the night. We have lives one after another. I got Idaho4 right here. I got Delphi right after. Then I have another Idaho4 case because then we're going to get into Dylan's interview. Yeah. Like I said, this is batch number 2. So this is the state's response, and comes now the state of Idaho by and through the Latah County prosecuting attorney, and hereby responds pursuant to the court's September 3rd, 2025 second order seeking parties' positions regarding the sealed documents. I'm going to zoom in here and make it clearer. Ooh. All right, so we pick up on number 44. We're picking up on 44. And that is the parties propose stipulated jury instructions. The state has no objection to this unsealing. All right. So, ooh, look at that. Right there. That gives you guys a little taste of what's coming up later. Ooh, daddy. Ooh, daddy. All right. Number 45. Again, they had to put the number that he listed it as, and then the date. Oh my, this is going so slow. State's proposed supplemental jury instructions. The state has no objection to the unsealing of this item was 45. 46 is the defendant's amended phase 2 mitigation witness list. For this item, the only thing that the state incorporates in its response to item 29 to the sealed state's response to court's order regarding requested redactions. And I'm guessing that they want people's names to be redacted that weren't out there publicly in any type of way. Number 47, this was filed on May 27th, 2025. And this is the exhibit. So this is exhibit S2 to the state's supplemental rebuttal disclosure, the penalty phase expert. So the state has no objection to the unsealing of this item. Again, on 527, item 48. Exhibit S1, which is to the state's supplemental rebuttal disclosure penalty phase experts. Again, the state objects to, because this is the exhibit, the state objects to this unsealing of this item as it is protected pursuant to ICAR and then whatever one. It contains highly intimate facts or statements, the publication of which would be highly objectionable to a reasonable person. And I think this has to do with all about Brian Kohberger's. Here we go. These are records of psychiatric care or treatment and professional counseling records related to an individual's condition, diagnosis, care, or treatment. So again, this is the state's supplemental rebuttal disclosure. So I have a feeling this has to do with one of the state's experts and what they were going to be talking about in terms of how they looked at Brian Kohberger's, if they were the ones that actually, hey, this is our state witness that's going to, interview him for X, Y, and Z. That's what I think that is. And I don't think that we're going to get anything like that. And I don't think that we should. Number 49 is, again, this was filed on May 27, 2025. And it's the state's supplemental rebuttal disclosure penalty phase expert. And this was 49. And they say, yep, nope, we have no problem with that. We get to 50. And this was filed on May 23rd, 2025. And what it is it's the defendant's evidence in support to offer of the proof for the alternative perpetrators. Now, again, just like back in batch 1, they have issues. So the state requests that the court redact the names and other information that could be used to identify the proffered alternate perpetrators be redacted pursuant. So this isn't just that we want the names redacted, and this is not just that we want the date of birth, if the date of birth is there as well. This is anything that us sleuths could break down and be like, okay, this is who they're talking about. Okay, this is who they're talking about. So the state says that as the court ruled in its September 3rd, 2025 order unsealing and redacting records, that was the first batch, this item involves identifying information of the proffered alternate perpetrators, the revealing of which would contravene the privacy concerns of these individuals and likely subject them to the undue harassment. So the C item 12 of the court's order, and that's what we're asking for this to happen here. Again, he's going to stay with precedent. However, he's been ruling that he's going to follow that. The state requests the court redact all text following the paragraph of the motion to include the names of the alternate perpetrators, descriptions of exhibits, and exhibits their numbers that include initials. Bottom of page 2 until page 5. They just want it all redacted. Again, this is for people like me and you that are diggers and that could see something. Give me just a little bit, and I can probably tell you who it is. But I don't want their names. I just want to know how they were being offered as alternate perpetrators. Like, what evidence is there that you are even going to say X, Y, and Z? Because the only people that I would have been naming as alternate perpetrators in this case would have been Molly and her friends and the undercover police officers, and that they were running some type of controlled buy, and it went way motherfucking wrong. That's what I see. I'm sorry, but I don't think Jack Decor has anything to do with this. I don't think that Jack Showalter has anything to do with this. And then my runner-up to that would be anybody that would be involved in the fraternities, if there was like a beef or whatever. But Molly McMichael and company being over there, same time as the homicides, I got a problem with that. Undercover plainclothes officers, now that I know that Molly and her peeps were CIs, or they were at least being spied on, or at that point, we don't even know. Yeah. Wee. Okay. Going back over here. So yeah, they just want bottom of page 2 until page 5. 51, same date, 5/23/2025. This is the objection to the court's request for the defense to submit a redacted copy of ex parte filing to the state. The state has no objection to the unsealing of this item. Number 52, 5/22/2025. Exhibit F to defendant's 6 supplemental response to discovery. So remember, the defendants, they were being asked questions and they wanted reciprocal discovery. So this would be something that the defense would have been providing the state, because just to make sure everybody understands that the state has no objection to the unsealing of this item. So Exhibit F to defendant's 6 supplemental response to discovery. So this is the state asking the defendant for something. Again, here you can see 53, 54, 55, 56. We'll stop here, but everything, the defendant's 6 supplemental response to discovery, defense objection to the juror questionnaire, and the court minutes, the closed session, all of these, the state has no issues with. So 53, 54, 55, we get to 56, and there's court minutes for a closed session, 5/15/2025. This item regards the status of an ongoing investigation into a potential leak in this case. So it's gonna say sealed now, is my opinion here, is what's gonna happen, and this will eventually be unsealed once whatever happens with this leak. 57, so on 5/14, defendant's offer of proof for alternate perpetrators. Listen, you can redact these names. Okay, I want to know what Ann Taylor and her team was coming forth with, and they weren't making the argument then. They were going to make it at trial. And so all they were concerned about is just that there would be no motion in limine, that they can't bring this out in trial. But even if there was a motion in limine, you can always revisit that and get a judge to overrule that, his own ruling, based on the way that the trial is progressing. That's why you should always still bring stuff up. That's something that I've learned. And you always want to preserve the record in terms of, it doesn't matter, like, object to the shit and lay your grounds for it. And it doesn't matter what the judge says, but if you don't make those objections and you don't make your moves, you can never go back and make arguments that, hey, this judge abused their discretion. So the state says the state requests that the court redact the names and other information that could be used to identify the proffered alternative perpetrators be redacted. Like I said, I'm not trying to figure out who the people were at all. I do not care. I want to know what angle they were going to be working in, because motive, like, as the court ruled on September 3rd, 2025, order to sealing, like we just talked about before. And so it just wants them to use the same type of ruling. Now for this one, they want it to be redacted from page 2 until page 7. Number 58, 5/14/2025. Second notice of filing defendant's proposed jury instructions. The state has no objection to the unsealing of this item. The notice of the state's amended exhibit list and motion to seal. Ah, yes, give it to me. Notice of state's amended exhibit list. Love it. No objection to this, okay? This is just their notice, though. This is just the notice. Here, however, on 5/13/2025, Exhibit S1 to the state's motion to reclaim exhibits. And here we have some issues by the state, and they say, pursuant to ICR 32G7, information regarding grand jury proceedings should be sealed. Other than that, fair game. Boom. 61. I told you guys there's only like 4 things I cared about with batch number 5. We're getting to the first one right here. 61. 5/9/2025. The parties' joint proposed jury instructions regarding the tip leading to the investigation of the defendant. The state has no objection to unsealing of this item. Boom. Give it to me. Give it to the world. All right. I want to see what the hell you would ever agree to, because you're lying to the jury. And I think that that's mind blowing. Okay. Next. On 5/5, this is number 62, the defendant's phase 2 mitigation witness list. For this item, again, the state incorporates its response to item number 29. It's just like, hey, the state's response to the court's order regarding requested redactions, and it just has to do with if people's names aren't out there, people's names should be redacted. 63 on 5/5/2025, there was court minutes. They were sealed, and the state requests the redactions at the following times that refer to a mental health diagnosis. So we just want you to redact these timestamps. And the state objects to the unsealing of this item as it's protected pursuant to, and it contains highly intimate facts or statements, the publication of which would be highly objectionable to a reasonable person. These are records. They're records regarding a psychiatric care or treatment, professional counseling records. So this is basically the same thing they talked about before. That was just the documents, and here's us talking about it in court when it was a closed. Like status there's some stuff that they had that we weren't privy to, because it had everything to do with when the state needed to have their expert examine Brian Kohberger. Now 64, 5/1/2025. The reply in support of state's motion for examination of defendant pursuant to And there was an extension of time because remember, they had to get a new expert because this person dipped out last minute for the state. So for the reasons outlined above, the state requests the court redacts references to a mental health diagnosis at page 4, footnote 2. The rest of it, fair game. 65. On 4/29/2025, defendant's objection to state's motion for examination of defendant pursuant to Idaho Code, blah, blah, and then for the extension of time. For the reasons outlined above, again, we have no problem to any of this stuff. We just want to be careful and sensitive to page 7, paragraph 2, sentence 2. 66 is Hurwitz declaration in support of motion for examination. Again, this is when he had to declare on why they needed this extra time and why they needed a new person. The state has no objection to that. Gage declaration in support of motion for examination. The state has no objection to that. That was one of the witness, somebody on the witness list, and I was like, why is this guy being called? Now I know why. If he was ever to be called, it had to do with them obtaining that new expert. 68, April 25th, 2025. It's the state's motion for examination of defendant pursuant and for an extension of time. Again, this is the actual motion for it. Those are the declarations. Here's the actual written motion. And so it was filed under seal. Now all we're asking for is page 2, paragraph 1, sentence 1, page 2, paragraph 2, sentence 4, and page 8, paragraph 3, sentence 2 and 4. And again, it just has to go with the, they just want to redact the references to a mental health diagnosis. Otherwise, fair game. 69. Not 420, guys, but 421. The defendant's phase 1 lay witness list. Of course I want this. Of course I want to know who Ann Taylor would be calling to the stand to tell like the story that they were going to tell. The state has no objection to the unsealing of witnesses identified as law enforcement or expert witnesses. The state requests redactions to law enforcement officers' home addresses. Obviously, don't want those. The state requests that the court redact the names of lay witnesses, names and addresses. Obviously, I'm fine with you redacting the addresses and everything like that. But if these people are known, no, like you can redact their birthdays, you can redact their addresses. But I don't think that, I mean, come on. Pursuant to, and then they're giving their code. The state incorporates its August 18th, 2025 response to court's order regarding sealed documents in response to this item. I wonder how Hippler's going to feel about that. By you making him go search for what the fuck you said on August 18th, 2020. I just had to laugh at that. Just why wouldn't you just copy, cut, and paste, man? Wouldn't you just copy, cut, and paste? I wouldn't want to deal with Hippler being, God forbid, I am being so inconvenienced. Copy, cut, and paste. Right? Okay. Next. I now know why Ann Taylor filed this one under seal, because a lot of it, I think she had to do a lot of describing things that had to do with Brian Kohberger's, the expert that in the past couple numbers there, talking about his new diagnosis and shit like that. That's, I'm hoping, okay, but I just don't understand. Maybe they felt like they had to lay it out really thick in case Hippler's just like, nope, we're going to put it all out there. I don't know. Okay. On 421 as well, the state's exhibit list. So the state requests redactions to the descriptions for the following exhibit numbers. Remember I told you guys, I was like, you guys, they were ready to go to trial. When I say that they were ready to go to trial, Hippler made them have all of this shit ready to go. So literally, like, you're just prepping your, how you're going to question your, the order that you're going to go in, how you're going to question your people. But for them not to go to trial, I mean, everything should have been ready because of how he was with these deadlines and getting stuff like this in. So going back over here. So exhibit number. So this is series 1 photographs. So I don't know, like state 1-78, and it's undisclosed named witness. Undisclosed named witness. So what they're saying is that these exhibits have something to do with witnesses whose names have never been known. And that was interesting to me. 78 through 88, that's 10. Okay. Undisclosed named witness. And so it's like, okay. Now, S189 through right here, 127. These are the description of the autopsy photo. Okay. We want that redacted. So I'm just like, okay. Yeah, I think they're just being extra cautious there. And I think it's respectful for the families. And I hope that Hippler, I mean, I don't know what they would have been naming these exhibits. You're supposed to not have them prejudicial either. When I learned a lot about that was when I was covering very briefly, because I was like, it's so ridiculous. Boone, Sarah, fucking idiot, right? What an idiot. She should have taken that plea deal. What an absolute moron. Anyways, the names of the exhibits were ridiculous. And Sarah actually had like an argument there. Like, you can't have these names of these exhibits be, because then the jury goes back and like they see those names. And in that case, those exhibits were wildly named. It was bad. They can't be prejudicial. They shouldn't be. You should be arguing about it if you're a lawyer. If you just sit there and let your client get hammered, though, so whatever. Again, though, she's a freak show, right? I think she went through, 12 lawyers? She went through a 12-pack of lawyers. Solid work there. All right, series 4 here, physical evidence, undisclosed named witness. I don't know how that has anything to do with physical evidence, but we'll find out. Maybe they give more of a description here. The state requests that the above exhibit descriptions include witness names that have not been widely disseminated by the media. I think Hippler's going to have an issue with this. I think he's going to look at these. If any of these people have talked in the media, okay, if any of these people have done interviews, oh, hell no. Their names need to be revealed. Okay. I'm sorry, but that is absolute shit. The revealing of these individual names would contravene privacy concerns and likely subject them to undue harassment. I don't know how that would be. I mean, how did you name these exhibits? The state incorporates its response to court's order regarding sealed documents filed on September 9th, 2025. Regarding exhibits S189 through S1-127, the state requests the court redact the autopsy photograph descriptions. The photographs which are a part of the autopsy report are exempt from disclosure. Yes, and the state submits the descriptions of those photographs fall within this exemption. In addition, the descriptions are exempt pursuant to highly intimate facts or statements, the publications of which would be highly objectionable to a reasonable person. Yeah. I think that should be redacted. All right. Number 71 is the state's witness list. The state incorporates the sealed state's response to court's order regarding sealed documents in response to this item. Again, my guess is that they want people that are not known, not said, and at the very least, maybe initials, no addresses, phone numbers, date of birth, stuff like that. Number 72, 421, defendant's objections to the state's requested jury instructions. I'm excited to see this because I can only imagine what these jury instructions were like, because this is something that you really want to, it's really, really important. When the jury's reading these, or supposed to be reading these and talking amongst themselves back in that room, and when they're trying to apply the law, you know, hey, the elements, hey, this, like, we're supposed to do this, and this is what reasonable doubt is, and da-da-da. I bet you there's going to be a lot to do with that word reasonable doubt. Just my guess. 420. Oh, they got not stoned, this staff. They were working on 420 here. The state's response to defendant's proposed jury instructions. State has no objection to unsealing this item. Good. 5 days would go by. And here's a filing here on 4/15/2025. This is item 74. This is the defendant's second response to Exhibit S1 to state's first supplemental request for discovery. So the defendant gave two different responses to Exhibit S1 to state's first supplemental request for discovery. No objection. Defendant's second response, no objection. On 4/15, Exhibit E to defendant's fifth supplemental response to discovery. The state requests the redaction of the potential lay witness names associated with items B, C, D, E, F, G, H, I, J, K, and M for this item. The state incorporates in its August 18, 2025 response to court's order regarding sealed documents in response to this item. In balancing the public's access to the information, it is the state's position that for the individuals identified above, the release of these names to the public could subject them to harassment, threats, stalking, and or other concerning behaviors by the public and or media, as exhibited through the release of other names associated with this case. Get the fuck out of here. The state submits the release of these names would be an unwarranted invasion of personal privacy. I'm sorry, they're not winning this. This is ridiculous. You guys, this is Exhibit E. So this is to defendant's fifth supplemental response to discovery. So the state asked the defense for something, okay? The defense, whatever it is that they provided here in Exhibit E, it had items that were obviously went with the letters, you know, probably like an outline form. And they have issue not with the letter A, okay, A, B, C, D, E, F, G, H, I, J, K, not L, and I don't know if it goes past M, but I don't think this should fly. Sorry. It doesn't, yeah. On 4/15/2025, the defendant's fifth supplemental response to discovery. So what we're going to see is what the state was asking for, or I'm sorry, the defendant's fifth supplemental response is their response to it. No objection to that, though. But the exhibits we have a problem with. The state's requested jury instructions. No objection. The state's requested jury instructions. I don't know if that was just, if it was a duplicate, because I think he made a mistake and wrote it twice, if I remember correctly. There it is. The state has no objection to the unsealing of this item. See item 78. And it's because you wrote it twice. And this is how they're choosing to handle it. Really weird. Really. Now, we're getting to number 2 and number 3 on my list of the 5 things that I wanted. Item 2 and 3. So I said I wanted the tip, which we're going to get just the tip. And I said the most important things that we need, I'm telling you, is the state and the defense's trial briefs. Okay, those are going to be big daddies, or they should be. It should be a lot of material, and it outlines how they would go about their version of the case and how they see things. You're briefing the court, and it's your trial brief, like how you plan on working your case. Ready? No objection, no objection. Thank God. Okay, thank God. Just, I want to read that. That is really, really important. It'll tell us how the big thing would be like, I want to see the defenses. Number 82, 83, and 82, 83. No objection. And this is the defendant's proposed jury instructions and the defendant's response to the state's first supplemental request for discovery, transfer of test materials. This would be number 5 for me. The state has no objection. Yes, give it to me. Next. Number 4. So this would complete my top 5. Boom, boom, right here. Number 84. Guess what we're getting into? We are getting into, oh yes, AT&T, baby. Come give it to me on 4/8/2025, Exhibit 4, in support of defendant's objection to the state's motion in limine, RE AT&T timing advance, baby. Come on. Let's go. The state has no objection to the unsealing of this item. You better have no objection to anything to do with AT&T timing advance. If you do, I call bullshit on you, Bill. And you're making Ashley do all this work. Look at Ashley Jennings. There she is. So again, this is batch number 2. This is how the state responded. I think it doesn't seem like it's trying to hide anything, except maybe some of these witnesses, right? Exhibit D to the defendant's fourth supplemental response to discovery. The state requests that we get some redactions here. It's to the reference names that have not been widely disseminated by the media. The revealing of these individual names would contravene privacy concerns and likely subject them to undue harassment. Sounds good. This is something that you asked of the defense to give to you. Okay. And the only thing that I can think of is that the state's trying to look like they're playing fair by we're asking for our people to be redacted. So if we're asking for the defense, hey, you know, who you plan on calling to the stand for, I can only imagine what this is, but we're going to just look like that we care about those people as well. I don't know. I'm just saying that's what it looks like to me. And I say, hell no. Let's go. Number 86. 86, the meatloaf, baby. 4/4/2025. This is a notice. So you'd make a notice, you go up to the court, and this is in about defense expert disclosures, exhibit D7-B. The state objects to the unsealing of this item as it is protected pursuant to, it contains highly intimate facts or statements, and I believe that has something to do with Brian's stuff. And then number 87, again, exhibit S1 to the state's first supplemental request for discovery disclosure. The state has no objection to the unsealing of this item. So this was just presented on, they unsealed it, or they put this out here, I think on 9/22, I want to say. And the defense has already got theirs in. So it's actually what, 9/19? Okay. And I expect Hippler to get back with us. I wouldn't be surprised if we get something here on Friday, you know, on what he's going to do, his rulings on this. And, but then we'll have another batch of this unsealing stuff. So all of these will go into my lovely spreadsheet. And it reveals at the end of it which ones he's deciding to either redact, completely unseal, whatever his decisions are. I felt like batch 2 took a little bit longer. Maybe I was just being anxious, though. I guess I can count my days, but hey. So, holy shit. Now, let me tell you, I called Whitman County today. This is going to close it out because you're going to join me back at 9:30 here for a Bomb Ass Live. Really quick, when I called Whitman County today to talk to the request for access to the public records to have to do with Justin Chance Stricker and Molly Marie McMichael. Okay. Let me tell you. Let me tell you this response. All right. Where is it? Okay, here we go. All right. Good afternoon. Our records department has received your request for all CAD notes, incident reports, and I'm just going to redact the rest. Based on the time needed to conduct searches and review records for applicable redactions, the number of prior pending public record requests, and the workload of Sheriff's Office staff who will be conducting the records searches and reviews, we estimate that the Whitman County Sheriff's Office will be able to fulfill your request on or before November 24th, 2025. Are you out of your mind? What are you talking about? November 24th. You would have thought I asked for all this body cam. And I didn't for a reason, because I need to see the incident reports first. There's no damn way. So I responded and said, either these people have long ass history of incidences between June of 2022 to present day. I said, or you guys are really, really backed up, because what the hell are we talking about here? No, Thanksgiving is when you want to get this to me. So September, October, 2 months. This shit's supposed to take 3 to 7 days. You type up this name, see what instances pop up, and give me the incident reports. Okay. And all I asked for was CAD notes from it. I didn't even ask for the 911 calls right now. And I didn't ask for the body cam or the dash cam yet, because I wanted to just look at these incident reports. I wanted these goddamn dates. I just want the fucking dates. I was pissed. You're going to quote me 2 months for literally no media. You don't need to go through dash cam yet. You don't need to go through body cam yet. How long does it take you to look at an incident report? Nothing needs to be redacted except for what? Very minimal. And I gave you 2 people. Piss up a tree. That's ridiculous. So no, I'm not satisfied with that. If you have any questions in the meantime, please let us know. Oh, I will. We need to hire more people. They are charging for the reports or no? Yes, they charge. They have a new system now, and they let me know their fees. They said, we have a new way of doing things. I said, I bet you do. Let's see. Whitman County Sheriffs, and they have like this whole big thing that they type up now on like a lead. Standard photocopies are 15 cents a page. Photocopies large format, black and white, 50 cents square foot. Photocopies large format and color is 75 cents per square foot. Scanned copies, all formats, 10 cents a page. Electronic transmittal of records, $1.10 per page. It's gigabyte or a fraction of there for electronic transmittal. CDs, DVDs are $2 a piece. Thumb drive is $5 each. Digital photographs on a CD are $2 per CD. Traffic accident reports are $5 per page. Photos is $1 per page, and you get 4 color photos per page. Body cam, 76 cents per minute spent applying redactions. 76 cents per minute spent applying redactions. I said, well, what if you don't apply any redactions? Does that mean I don't get charged? Because you're just watching your own shit? I mean, what? The sheriff may require a requester to enter into a written alternative fee agreement for voluminous records requests or frequently occurring requests from the same person. What? I can't help it if I am a active member of society with our rights, okay? But you want me to get into an alternative fee agreement? You want me to get a contract? Okay, well then I want special privileges. I want to be treated as VIP. If I'm going to pay, I have no problem paying. I want VIP treatment though. I am not waiting around for 2 fucking months. If I am a requester that you think I request a lot, I don't. I actually request very intelligently because I know how to weed out stuff that I do not need. Like I would never request that I need. Like I break it down. I just know what I need. I know the scruff. Get it out of here. I don't need that shit. The customized service charge is an addition to the fees set forth above. The customized service charge. What? The sheriff may assess a customized ID service charge if A, fulfilling the request requires use of information technology resources to identify, locate, format, or translate a record, data compilation, or to provide electronic access services. What? This is Tina with What the Fuck Translation Services. What the fuck are you talking about? The sheriff shall provide the requester an estimate of the customized service charge and must not charge more than the actual cost of providing customized access services. The sheriff may waive any fee whenever it deems necessary or appropriate. Exactly. Is that right? This is public interest. This is very, very, very concerning. Okay. Well, clearly nobody went through that, the body cam that we last saw, right? Nobody went through that. Hot mic. That was a hot mic. Again, this is Washington. This is Whitman County. I didn't even do Justin yet in Idaho. Yep, this is why folks need grants to do research. Well, again, everything can stay within reason. It's when you do like these blanket stuff, but this is just their new policy and procedure since May of 2025. I think they put it in place so they could start capitalizing on a lot of things that they knew that they were going to get a lot of requests with this case. But when I saw that the body cam footage is 76 cents per minute spent applying redactions, plus the actual cost of the storage device and actual cost to mail the records, I said, well, what if you don't have to redact anything? Then I don't get charged 76 cents a minute, right? Because it says applying redactions, right? But I think someone needs to fix that in the legal department because that doesn't make sense. But I'm going to use them and I'm going to word salad them back and say, well, this says that the body cam footage is 76 cents per minute spent applying redactions. If my body cam hardly has redactions, then the 42 minutes that you went through and you only had to redact 3 different points in minutes of there, 3 minutes times 76 cents. I'm not paying 76 cents for 43 minutes that you only had to redact 3 minutes worth. You're just watching what's going on here. Anyways. Okay. That's all I got here. The next one is a 9:30 live. I'm starting basically right when I get off here. Those of you that are interested in the cell brights, okay? I am going to start breaking down the Delphi case. And I am hot. Okay. These people that are on this jury in Delphi, Indiana, for the Richard Allen case, shameful. And I'm going to show you guys why. Join me. And then after that 9:30 live that I'm doing right now, then I have Dylan Mortensen. Holy shit. Holy shit. Her time spent with Mallory has been released. So I'm going to go over the Dylan Mortensen interview at MPD on 11/13/2022. And I'm going to, I can't even believe there was no, I was in a state of shock. Dylan said that after she saw Brian Kohberger, or the guy that was in there, that she does not know if the door was shut behind, the slider, because she ran downstairs. What? She immediately ran. I thought she locked herself back in the room. What's going on? If she immediately ran downstairs after seeing the dude, right? This blows up the narrative, and all the text messages can go straight to hell. If she immediately ran down after seeing him, then it's all bullshit. Or the person was still in the house way past that 420 speeding away. Can't have it both ways. See you guys back here soon. Peace out. Just for a second, though. Come back and join me really quick. Let's do it.